Nobody.
Remain seated, come to order. Orders again in session.
Good afternoon, back to the record to the Measure C cases.
Thank you, Your Honor. Your Honor, I'd like to accomplish three things this afternoon during my presentation. First, I want to talk about what's required for the economic impact on facial takings claim. Second, I want to talk about the administrative process under Measure C. And third, I want to talk briefly about vested rights and amortization. And I think as we go through this, and I hope to persuade Your Honor, that plaintiffs have confused a facial taking with a temporary taking. First of all, I'd like to start with the Tahoe case, which interpreted what Lucas was saying, both Supreme Court cases. Could we switch to the camera and put this site from Tahoe? Expand on it. Your Honor, this is at 329. It's in the PowerPoint outline that I gave you, Your Honor. The categorical...
Page 329 of the file.
Correct. Its full site is 535 U.S. 302 at 329. And there, the U.S. Supreme Court, interpreting the categorical rule they set up in Lucas, said, quote, the categorical rule that we applied in Lucas states that compensation is required when a regulation applies no matter of all, open quote, all economically beneficial uses, close quote, uses of this land. It goes on to say, open quote, the extraordinary circumstance when no productive or economically beneficial use of land is permitted. So in other words, they're explaining that's what a facial taking is. And then finally, they conclude, quote, the emphasis on the word, quote, no, in the text of the opinion was in effect reiterated in a footnote explaining that the categorical rule would not apply if the diminution in value were 95% instead of 100%.
How does that square with, I agree that this language is pretty clear. How does that square with the holding in Lucas that recognized there were some other uses that could have made? That maybe it was 2%, 3%, I don't know, that turning into a parking lot or a boardwalk or a food trailer on the property?
Well, Your Honor, I think, first of all, we have to appreciate, while it's still good law, Lucas is a very old case. But secondly, the court was looking at a full taking of houses. And here we're talking about whether there's been a full taking of plaintiff's business. And I think if we look at the evidence, and I'll turn to that next, their declarations do not establish a full taking.
Are you saying all claims collectively will suffer?
We'll talk about the mineral rights in a second. So for now, I'm talking about all the active oil producers. So if I could turn, Your Honor, to the evidence submitted by Chevron, this plaintiff's taking evidence. And I'm going to start, and this contains declarations from a variety of the plaintiffs, including Chevron and Aera. And under tab 3, we have Chevron's witness, Dallas Tubbs. And he says, page 27, paragraph 60, quote, based solely on the implementation of Measure Z, Chevron will lose substantially all economic value of its property rights within the San Ardo Field. Saying substantially, not all, on immediate implementation. Let me turn now to Aera's witness. This is Mr. Kemp, and in the Baker and O'Brien report, this is all the tab 7, page 3, he says, quote, in response to Measure Z, operators can be expected to aggressively reduce fixed costs, maintenance costs, and replacements. This situation would accelerate the decline in production, which is estimated to approach 25% annually, close quote. And Mr. Dinser accurately paraphrased that when you asked him, when will this take, what will the impact be, and he said that. And counsel for Aera said that this declaration and the language I just quoted applies to all of the existing operators. So, right away, under this 100% equals 100% point that Tahoe makes, we don't have a full take, and you don't have a facial take. What we have, assuming plaintiffs can prove their claim, is a temporary take. And that temporary take, if they don't receive any exemptions, and again, assuming they can prove their claim, becomes a permanent take. But the world of facial take is here on the left, and temporary and permanent is here on the right. That's where I think there's been a bit of confusion. And I think the same thing will apply in a few minutes when I talk about the CRC situation. Two other points while we're still here. Go ahead. We've gone back and forth and said a lot about no net new wells or no new wells. Your Honor knows we have a disagreement. I just reiterate that we believe the findings that seek to prevent expansion create any ambiguity that's necessary to clarify our position. And then a second point on relating to evidence. We stated our objections to the use of the Burzlaff deposition, and Your Honor had some comments this morning. And then finally, if the court is inclined to rely on the statement that we produced in response to a Public Records Act request by the supervising appraiser about the economic impact on the county of Monterey, in addition to it not being relevant, he's not the assessor. He doesn't speak for the county. The assessor actually did not take his statement. He wrote a different statement. And finally, what was put into the record, in the ballot material, in the administrative record, was a statement, I believe, of the auditor. So,
with the auditor's statement, made in his capacity as auditor for the county.
yes.
And he's appraiser is someone who was hired by the county to assess the
No, the assessor's office is used to help assess property, and he that office is part of the county employees. In that office, they have further county employees who are appraisers, and this person is the supervising appraiser.
and employed by the county.
Correct.
And acting in that capacity when he made this statement.
So the statement was made as part of his employment, but he was not acting on behalf of the county to state the county's position with respect to Measure Z, or even his office's position.
Is he doing this on his own?
Essentially, if I can.
Sure.
Clarification. He was asked to do a write-up by his office. He was provided to the assessor. He rejected it and he resigned. Okay. So, could we go with that this time? We're dealing here, Your Honor, with 3 administrative remedies. The first is amortization for oil and gas wastewater. There's actually a 5-year automatic amortization period, and then, oil and gas wastewater impoundment or re-injection. And then there's a potential 10-year extension of that 5. Secondly, we're dealing with an exemption for vested rights, and third, we're dealing with an exemption for takings. Now let me talk about CRC, and I want to talk about the administrative procedures and start where essentially they ended their presentation. Your Honor, CRC draws a distinction between the San Mateo case and Measure Z situation, which I don't think conforms to facial takings law. May I ask the assistant to pull up slide 37 of the CRC presentation? It's actually page 37. I think it's further on. Your Honor, if you take a look on the right side, CRC is saying that, actually look, if you look at the whole slide, CRC is saying the difference between the San Mateo case and Measure Z is that in San Mateo, you walk your way through the administrative process. And then in the end, if you're denied, you have a taking. And that's how they attempt to distinguish what would be an as-applied claim from a facial claim. So if you look on the right, they argue, Your Honor, there's a taking that's occurred the minute the stay gets lifted and Measure Z is implemented. But then as they walk down, they point out that if it's granted, what they have is a temporary takings claim. Your Honor, I'm not aware of any facial claim that can be transformed into a temporary takings claim. There's no such thing. What they really have is a temporary takings claim because there's a potential when Measure Z is passed, implemented, that it won't fully take their property. Now, if in fact they have a claim and they can prove it and they are denied any exemption from it, then that temporary takings claim becomes permanent. But a facial...
I'm not sure I follow. If you can elaborate.
Yes. So a facial takings claim is they pass a statute, ordinance, initiative and implement it. And you've had a full deprivation of all economic rights. Full stop. That's it. Anything less is not a facial, it's an as applied. And so here, if they are correct, and we're not conceding this, but if they are correct, that they are fully unable to develop their property the minute Measure Z is implemented against them. But then, 6 months, 7 months, 8 months down the road, they get an exemption, they would no longer have a full take. They'd have, as they say, a temporary take. That means then that the alleged taking at the beginning is not a facial take. It's an as-applied that's temporary.
Well, actually, doesn't it have to be determined under the proposed rules to be determined to be a taking before you can even apply for the exemption? That the language of the measure?
It has to be determined as part of the administrative process. That's correct. But Your Honor, so if as part of that process, the exemption is granted, and that possibility is out there the minute Measure Z is applied to them. Excuse me, implemented, I don't want to mix terms now. The minute Measure Z is implemented, but there's a possibility that it will not be a full take. You're not dealing with a facial take, you're dealing with a temporary that becomes permanent if in fact you don't receive the exemption. Let me try an analogy that may help clarify. If the county passes an ordinance that says a certain type of business, pick any type, is just not allowed to operate for 3 months, only 3 months, but not for 3 months. And you have an ongoing business and you've been making money on it, that would be a take. But it would be a temporary take because after 3 months, the moratorium on your operation goes away. It wouldn't be a facial take, it'd be temporary.
Well, in the situation example that you just gave, at the outset, by a very definition, because it was only going to be for 3 months. Here they're saying you can't. You cannot. You can use these undeveloped medical rights at all. Period. And medical direction exemption may be wrong. But at the outset, it's a complete ban, is it not?
You know, we've argued whether it's a complete ban, but assume that it is, for purposes of your question to me. I'll assume that.
And I'm sorry, but here, to focus a little bit, without getting into the factual nuances about injection and storage, the prohibition of drilling any new wells on property where mineral rights are and no production has ever been undertaken would be an immediate and complete ban on production.
I don't want to argue evidence, but let me assume that it is. Let me assume that the ban on no new wells ends up preventing production for a mineral rights owner.
And I'm just talking about the ones who haven't done any production, exploration, or drilling.
I'll assume that for your question. Even if it is a complete ban, it's not just all operations and therefore it's a complete ban. It's also how long is it? Because as long as there is a possibility that that will not affect you, as long as Measure Z is law, then you don't have a facial take. And you're not without remedies. You know, if I prevent you from operating for a year or 2 years, and a court will later say, you know, that was a takings, then you'd be liable for the period of the temporary take, as they point out. And if the court said that was a take, or you didn't get your exemption, then I'd be liable for the permanent. But the point is, when you look at a facial, it's got to completely deprive you of all rights. Not just now, but also you're not going to have a chance.
So is your position that so long as there is a possibility of an exemption, it cannot be a permanent taking, a facial taking?
That's right, and that's not a radical position. That is why we have this administrative process. We can argue and talk in a second about whether that process is appropriate, but that's why, because the courts don't want to have to decide. Well, first of all, it allows a way for the administrative process to resolve the problem.
We did have some discussion about how that would work.
All right.
And what about Birkenfeld? You know, the Berkeley rental ordinance case. They had to go through a hearing, the rent control board, and then to get it decided, to get a decision. And that process could take about a year. The proposed rules are, you apply for the exemption, the county's got an extra period of time to respond. You go to a hearing officer. The hearing officer makes a decision, a recommendation, apparently, which then goes to the board of supervisors and it's delivered for a month. This takes more time than the Birkenfeld process, does it not?
I don't know how much time they each took, but let me suggest that the Hensler case laid out exactly how this should unfold. And we had citations to it earlier. So, Your Honor, in Hensler, the California Supreme Court was looking at the California Coastal Commission's process. And part of that process is the Coastal Commission made a decision on whether there was a take. And the process, as originally set up, required a plaintiff, if they disagreed with the conclusion of the Coastal Commission, to file a writ of mandate to Superior Court. And the California Supreme Court was worried about, as counsel has said, many of the same issues that we are wrestling with here in Measure Z. At page 16 of Hensler, by the way, the site is 8 Cal 4th 1, page 16. The court said, and it was cited this morning, quote, an administrative agency is not competent to decide whether its own action constitutes a taking. And in many cases, administrative mandate proceedings are not an adequate forum to try a taking claim. And they go on to say, in the administrative hearing for the Coastal Commission or any administrative hearing, there's a possibility that there won't be a chance to call witnesses, cross-examine, and so it's not the full-on protection that a plaintiff for the takings claims wants and is entitled to, and they shouldn't be then constrained to only filing a writ of mandate. Nevertheless, the court said, and this is now on page 15, a property owner is, of course, entitled to a judicial determination of whether the agency action constitutes a taking. And they cite the Heaton case, which I'll talk about in a second. And then it goes on, quote, administrative adjudication in the course of exercising an administrative agency's regulatory power, if subject to judicial review, does not deny participants the right to judicial determination of their rights, close quote. So they're saying, process may have flaws, the agency may not be appropriate to make a decision on takings, but we need to go through this process. And
How do you reconcile that with Birkenfeld?
okay, well, let me just, if I could just finish up with Hensler. And so the court then explains what your rights are as a property owner. if you disagree with the results and the way the administrative proceeding was handled, at page 16 they say you can file a writ of mandate. That's not all, but they say initially, quote, if the owner believes that the hearing before the administrative agency was not adequate, the owner is assured a full and fair hearing by exercising his right to join an inverse condemnation action with the mandate proceeding. Close quote. So that's their remedy as to the problems with that process.
Was that for as-applied takings or facial takings? The facial taking is a question of law, isn't it?
I believe Hensler was an as-applied, Your Honor. No. Hensler rejected the claim because plaintiffs failed to exhaust their remedies. I don't want to go a step further and say I know it was a facial takings case without reading it more closely, but I do know that the failure to exhaust was why the claim was sent back down. And then the California Supreme Court went on to say, in terms of the damages you might have incurred during the period while you were going through this administrative process, if it was unreasonable, the remedy is, at page 15, quote, the landowner is entitled to damages for any loss of use of the property beyond that to be expected as part of the normal permanent process. Moreover, the expense of a meritorious taking claim will not be borne by the owner. Not only are damages for temporary taking available, but the owner's reasonable costs and attorney fees must be reimbursed by the local entity. If the owner establishes the restriction on land use as a compensatory taking. So the remedy, and I'm not prepared to talk about Birkenfield in great depth, Your Honor, where it's going to get covered tomorrow, but the remedy, if the process is unwieldy or overly delayed, is twofold. You have the right to a writ of mandate, and you have a right to damages for the unreasonable delay.
How does that unfold for twofold process? We have a petition for writ of mandate, the standard for review of which is
Substantial evidence, which was a concern of the courts. And then, as Hensler says, you're entitled to combine that with a complaint for inverse condemnation. And so, what we're used to seeing is a lawsuit comes in after the administrative process, and it has both. It says that it challenges the process, and it also has inverse condemnation. And then, in deciding the petition for writ of mandate, if the court says it's a taking, then we get to the decision Mr. Dinser had pointed out. Do you want to pay, or do you want to, if the court finds a taking, or do you want?
So we end up with 3 lawsuits.
Well, we have 3 lawsuits now, because I believe they have alleged all forms of taking and a writ of mandate. So Your Honor, we're deciding the facial.
Hopefully, if it gets decided, not every one of these will result in the same process.
Okay. Let me just talk briefly about 2 other cases that were cited in connection with the articulation that this administrative process under Measure Z doesn't conform to the law. The plaintiff's CRC cited an action apartment, which is 94 Cadillac 4th, 587. And in that case, the alleged taking was the fact that an ordinance required the landlord to send interest on the tenant's security deposit to the tenant. And the court said, the administrative remedy is not something you should have to go through, because the rent control board only has the authority to adjust rent. It does not have the authority to determine if there is a refund of the security deposit. It's not within its scope. And the court said at page 607, yet the issues presented, the validity of the 3% interest regulations, raises a single discrete point that is not related to whether landlords are making a fair return on their property. Your Honor, healing is also a very similar case to the Hensler case. They had the same concerns as Hensler did, and Hensler went ahead and quoted healing saying, we have the same concerns, and those are the concerns that I was talking about, how Hensler suggested they should be remedied. But he even went a step further, but also distinguishes the situation. And this is 22 Cadillac 4th at 1158, and the pinpoint site is 1178. And the court said, quote, there's one more reason why the constitutional takings issues cannot be determined by a petition of writ of administrative mandate. And there's more language, and then it continues on, quote, the Coastal Commission is not legislatively authorized to consider much of the evidence and many of the issues relevant to an inverse condemnation. To the contrary, the Commission's powers and duties are only those vested in it by the Coastal. Let me just address one more point about the concern of the court applying law to an application. Already within the county, separate of Measure Z, the process requires ultimately working its way up to the board for the county to determine whether there is a vested right. That's a constitutional right that's protected. And then deciding what's an appropriate exercise of that right. They have to do that already. In land use, applications come in, and the county has to decide whether the treatment of that conforms to all laws. So while we may disagree over how cumbersome or not Measure Z is, the notion of applying legal concepts, constitutional legal concepts, by the administrative agency and considering applications, and that's why there is language in San Mateo that says that the measure shall not be, I don't want to misquote it, but, and if there's a concern, I'll get the exact language, but effectively, the ordinance is not to be applied if the application of it does not comply with the law. And
so somebody applies for an exemption. CRC applies for an exemption, goes through the process. It's determined, yes, it would be a taking at the administrative level, or supervisors to just be able to take it. There'd be another lawsuit over determining what the amount of compensation should be for that taking.
I don't think there should be, as long as the stay is in place, because there wouldn't be a temporary claim. And now, they would be able to fully exercise their rights.
That's assuming this court grants a stay against the enforcement.
That's correct. If, Your Honor, if the stay, there isn't,
The basis for which would be what? If it's unconstitutional?
well, okay, so let me back up. So, in our world today, there is a stipulated stay in place. And therefore, there are no temporary takings claims, damages accruing. After that,
At least on its face.
right, after that, it depends upon how your Honor rules. If Your Honor were to rule that there's no facial take here, the prudent thing would be for us to nevertheless still have a stay while that issue gets fought out, because if Your Honor's conclusion that there's no facial take were incorrect, then we wouldn't want temporary takings.
When you say, well, that gets fought out, are you
Appeal.
talking about
Appeal.
by higher courts?
That's right.
And everybody knows, regardless of what the court rules, somebody's going to take it out.
That's right. And when we get into the presentation on due process, there'll be a more informed discussion of the types of procedures where public agencies.
Yeah, I am concerned about that, and it really is an important part of determining the significance of this possibility of an exemption being granted. And that is a tremendous concern to the court. Because we've got an agency that is going to be tasked with deciding whether its own regulation constitutes a taking. And there are darn good reasons why we don't let the agency that's going to be having to pay whatever the cost of the taking would be, decide whether or not it's a taking in the first place. Also troubles me is the fact that even if there was proof beyond a reasonable doubt that it was a taking, under the exemption procedure, it's outlined, the board of supervisors could say, we're still not going to grant the exemption. By way of the Chevron could come in with substantial evidence which showed by a preponderance, although there are no burdens of proof set forth in this ordinance.
It's substantial evidence, Your Honor.
That's not a burden of proof. That's quantum of evidence to sustain a finding.
Right.
But what is the burden of proof to establish whether an exemption should be afforded? There is none that I see in there. So someone could come in with substantial evidence. Maybe it doesn't even preponderate.
That's right.
And so they could grant it. And then somebody from the Orradre family in South County comes in with proof beyond a reasonable doubt. Mounds of evidence that it would be a taking. And the board of supervisors need not determine it's a taking. But even if it does, we can say we're not granting the exemption.
Well, Your Honor, if they were the final say, you'd be correct. But they aren't. The court is.
What is the point? Why would we have people go through this process if it's susceptible to that kind of unequal application. We're in a political forum, no less.
Two reasons. One, as was articulated this morning by council, there's a very real chance that the pressures work the other way, and the board has to consider their decision very carefully. And if they were to grant the exemption, then we don't have to fight over whether there's been a takings. And then secondly, Your Honor, that process, while it may not be as swift as Your Honor would like to see, that's the process that Hensler has told us we should follow.
It appears like it's a pretty lengthy process. I mean, it easily can take years.
Yes, Your Honor, and takings claims typically do. They just take time.
Not in this program.
Okay, but Your Honor, the remedies if it's taking too long is they have temporary takings there as well. Your Honor, I'd like to talk now about amortization. Very, very short discussion. I think there's a bit of confusion on amortization. I think the argument was that it's not legal to apply amortization here. Amortization is a way for the owner to recoup his, her, or its investment. Not necessarily allow him or her or it to operate forever, but to recoup it. It's a constitutional concept, by the way. You have to make sure that what you're doing doesn't unreasonably amortize it, and it's unreasonably not provide enough time to operate to recoup your investment. And it's a way for agencies to phase out land uses without having to condemn the property and take it. And as long as they fit within the criteria, and it's a concept, a legal concept as to what's a reasonable amortization, then they don't have to do that. So whether the property can be moved, or whether it's mineral or oil and gas, that goes to what would be a reasonable return on the investment. So, put it another way, you don't get a right to operate forever at a particular location because your property can't be moved if it's an oil and gas operation. Rather, you are entitled to make sure that any rules that are applied to you allow you to have a reasonable amortization.
What about this notion that because of the 5-year cap on underground injection and storage, bring this all basically to a screeching halt in 5 years? That the amount of revenue that could be produced by continuing production in that period would be more than offset by the cost of shutting down the operations. And there's plenty of evidence in the record that you don't just pull your equipment and walk away from the field. You have to apply for an abandonment permit. It has to be done in a certain way. It costs money to do it. You have to do state approvals to do it. But what about the idea that although there may be the opportunity to realize some income by continuing production during this phase out period, and the cost of phasing out will basically eradicate whatever that income might be?
Well, Your Honor is asking a question about what, is 5 years or even 10 or 15 with extensions a reasonable amount of time because of the investment that's been sunk in to the property. And Measure Z has the 5, 10, 15, but it also has an exemption for a vested right. administrative record at 159, 160.
Which, if found to exist, would allow what?
The agency, again, subject to court review, the agency would be obligated to determine what is a reasonable period of time to recover your investment back to expectation. 5 years, 10 years, 15, 20, whatever that is.
What about the lack of standards to determine, basically handing over a judicial function to an administrative agency or a local governmental agency to determine whether something is an unconstitutional taking? Isn't that something that really ought to be decided in a court?
There is a concern about that, and the California Supreme Court has expressed that. Having said that, the application of constitutional principles to different applications is something that agencies have to do, and that's why they often have this language, and I think it was San Mateo, the application of apologies, that the measure should be applied only to the extent that it doesn't violate the law. And Your Honor, that comes up in the First Amendment context too. They have to make decisions that make sure that they're the way.
What about the First Amendment case Mr. Thompson cited this morning? Yeah, banning sale on the boardwalk, except to the extent that the First Amendment protects that kind of conduct.
Well,
and that was held invalid because he basically said, you figure out what the Constitution requires.
well, I'll go back then to the more specific situation we have, which is a land use application and a takings, where the California Supreme Court has said that even if the process isn't as robust as is necessary, the fail-safe is the Superior Court and court system. So, Your Honor, let me just wrap up. I started and I said, and I think I read portions of plaintiff's evidence, not the mineral rights parts, but the other parts, where they haven't had a full take. That to the extent that there is a substantial hit, that doesn't mean that 100% is taken right away when the measure is passed and implemented, and therefore it's not a facial take. I've articulated, I think, the same issue with respect to CRC and the mineral rights owners. Even if there were, and I'm not agreeing that there is, but even if there were, the minute the measure is implemented, an inability to use their property at all, as long as there's an opportunity for the administrative process to relieve them of that, then you move outside of the facial take. That's it, Chairman.
Okay, thank you, Mr. Snow. All right. Yes?
Good afternoon, Your Honor. Colin Petzman will be speaking for you.
Okay, thank you. Good afternoon.
Good afternoon, Your Honor. 1 second. Set up.
Thank you, Ted.
Good afternoon, Your Honor. Colin Kretzman for Interveners Protect Monterey County, Dr. Laura Solorio. I'd like to start today by addressing head-on some of the evidentiary issues and the phrases that we keep hearing from the plaintiffs, both today and in the first few days of arguments. I keep hearing phrases like the evidence shows, or we have submitted declarations that show. And I know the court has indicated that evidentiary issues can be decided at a later point, but I raise it now because so much of the plaintiff's claims, especially in the takings segment of this week, rely so heavily on those factual declarations and other documents submitted by the plaintiffs. And so I want to take a step back and talk about the scope of review for what we have before the court today, which is a facial takings challenge. In this phase one, we are examining just the facial validity issues, essentially a writ proceeding, and the court's review is limited to the text of Measure Z, the relevant laws and statutes, the legislative record that the county has lodged, and a few documents that might be appropriate for judicial notice concerning backgrounds.
Don't we also have a particular request for declaratory relief, however, in this action?
Your Honor, the cases don't make any distinction for facial challenges to the constitutional validity.
Well, how do you deal with the Keystone case, which basically says it's up to the person claiming a facial taking to establish certain things?
The Keystone case doesn't quite address the situation we have here. That was a facial claim that the court ruled was unripe for adjudication. And they sent it back to the administrative agency to get more facts. And they said, come back to us later when you have those facts developed, and we'll analyze it under the Penn Central test as an as-applied takings.
So how does that differ from you? I mean, if they didn't put any evidence of what their interests were, that they were undeveloped, couldn't you just say, well, they haven't shown that there's a facial taking because they didn't establish those facts?
That's exactly right, Your Honor. That's why facial takings claims are so rare and difficult to prove, and the case law admits that this is a very high bar. In facial challenges to the constitutional validity of a statute or ordinance, the court considers, quote, only the text of the measure itself, not its application to a particular circumstance of any petitioner. That's from Toby versus City of Santa Ana, 9 Cal 4th, 1069.
How do you reconcile that with Keystone, saying you have to establish? You have to establish factually that you have an interest, that the regulation affects it, and that it deprives it of all economic liability. How can one possibly do that without putting on evidence?
For a facial analysis, we need to look at the text of Measure Z, and if it is clear from the text of Measure Z that it affects total and complete taking, the mere enactment of the measure affects that taking, and it's unavoidable or inevitable in application, then there's a taking. Everything else is unripe for adjudication. You need to go back to the administrative process, develop your facts there, and get it analyzed under a Penn Central as-applied takings challenge. Let me refer you also to Dillon versus Municipal Court for Monterey, 4 Cal 3rd, 860. Facial challenges are, quote, directed solely to the language of the enactment and not to its application in a particular case. And in the California appellate case that actually took a look at the facial takings claim and said that these individual facts are irrelevant. We cite this in our evidentiary objections, the NJD Limited versus City of San Dimas case. They say a facial challenge to the constitutional validity of a statute or ordinance considers the text of the measure itself, not its application to the particular circumstances to an individual, and that's at 1439. And again, Keystone doesn't change that. Keystone said the facial challenge is based on the text, and you can't tell that you've exhausted your administrative remedies. You have to go back and do that. So the facial challenge fails. If, at a later date, you establish enough facts to bring back the as-applied challenge, then you can do that. I would need more facts. And let me, I'm sorry, one more from the Supreme Court, Your Honor. Because the appellee's taking claims arise in the context of a facial challenge, it presented no concrete controversy concerning either application of the Act to particular surface mining operations or its effect on specific pieces of land. So that's the Hodel versus Virginia surface mining case, 452 U.S. 264, explicitly saying we don't need to take a look at specific property owners or how it affects particular operations in a facial takings. We are in the world of just looking at, on the face of Measure Z, whether we can tell from that text if it affects a takings.
Well, so then on its face, does this measure prohibit and prevent development of any mineral rights interests that have not heretofore been subject to development activity?
We don't know that because the text of Measure Z in Section 6B says you have to go to the county first to establish that you have protected property interest, and then the county decides based on that.
So is it your position that any time there's some administrative procedure that can be involved, you can never have a facial challenge?
That's what the holding says in San Mateo County case. It had the exact same provision as Measure Z Section 6B, and that court said that's enough to defeat the facial takings because we can't say for sure based on the text of the San Mateo measure that in every case, inevitably, it's going to result in a 100% takings. And if that sounds like a high bar, it's because it is. There are very, very few facial takings claims that are successful for this very reason.
So are you saying that in order to have a facial takings, claims sustained, it has to inevitably result in a 100% taking as to everyone affected?
It has to be shown that the measure cannot be applied in a way that would avoid an unconstitutional taking.
Can it be applied to someone who has as yet undeveloped mineral rights interests without affecting an unconstitutional taking?
Yes, because there's an exemption process for that.
And that in turn depends on the viability, the validity of the exemption process, right?
And the San Mateo County case looked at the exact same provision and addressed this exact question. That answer is something that we know, that the exemption process is enough to defeat a facial takings challenge.
Assuming it's viable, and assuming it's a valid exemption process, a constitutionally valid exemption process.
Yes, and the San Mateo County Court held that in Measure A of San Mateo, that exact clause was constitutionally valid. It defeats a facial takings.
What exact clause?
Sure. Let me skip to that. So, going back to your Honor's question, a facial regulatory taking has to be, one, unavoidable. That's from the San Mateo Coastal Landowners Association case. A claim that a regulation is facially invalid is only tenable if the terms of the regulation will not permit those who administer it to avoid an unconstitutional application to the complaining parties.
So, there's the provision here, under section 6C, that says the Board of Supervisors can grant an exemption, but it doesn't have to, even if it's an unconstitutional taking. Prevent those who administer to avoid an unconstitutional application of rights.
Yes, because it's not unavoidable. The county, once they grant an exemption, if Chevron comes and says we cannot avoid, there's a takings because we can't do X, Y, Z, and they come to the county and ask for an exemption, the county at that point has a choice. It can say, we don't see a takings problem here and deny the exemption. And at that point, we've got right claim for an as-applied takings. The county could also grant the exemption if it finds a takings, and Measure Z requires them to do that. And then Chevron can do the operations that it intended to do, where its property rights deemed to be constitutionally protected. Or, the third option is that the county finds a taking and wants to ban the activity anyway, prohibit the activity, and grants compensation. So it's not a guarantee that Measure Z on its face will result in a taking each and every time it's applied.
What about the nature of the forum that is provided for determining this exemption? Namely, a Board of Supervisors hearing, in which presumably endless lines of people can come up and state whether they oppose an exemption or not. With no discretionary constraints imposed on the board in deciding whether to grant an exemption or not. Because the words of the ordinance say that it may grant an exemption, not that it must, if it finds an unconstitutional.
I think I hear a couple different types of concerns with the process in your question, so let me try to break those down. Is the county the appropriate place to determine property rights? I think was one question. And of course, the San Mateo case determined property rights. It had the exact same provision, and the San Mateo County was allowed under this provision to say we can avoid official takings by applying it in a way that avoids unconstitutional application, and that was left up to the county. Same thing with Monterey's Measure Z. It's left up to the discretion of the county to decide what the land use decision will be based on a variety of factors. And this is something that cities and counties do all the time. They take a set of laws and then apply them to a specific project or development proposal. And this is no different than what they do every day. And in most cases, they're thinking about, is my decision today going to affect the taking? So they are well equipped to make these land use decisions at the county.
But the enabling ordinances in those situations expressly provide that even if they find it's an unconstitutional taking, they can nonetheless deny the permit or exemption.
I think you're focusing on the May text of 6C. So what that gets to is, skip ahead here. the county's administrative process works like this. I'm pointing to slide 9. The claimant thinks there's a takings, applies for an exemption, and at that point, the county will look at the factual record, all of the evidence provided by the oil company, all of the relevant evidence that other interested parties put in the record, and decide based on that, is there a taking? If the board finds there's no taking, then they'll say, you can't continue the activity that you're proposing to do. And that's subject to judicial review, as is any agency decision. That's all of administrative law, is courts reviewing what agencies do and making sure that they apply the law in a way that's not erroneous or arbitrary or capricious. The board could also find that there is a taking, and this is where they have a decision to make. They may award just compensation and deny continuance of the activity in question, or they may grant an exemption to allow.
Does the statute require that they do either of those things, or the ordinance?
Yes, that's what 6C lays out, is the process for doing that, and the county is adopting implementation measures.
Where does it say that if they find a taking, they have to either award just compensation or grant an exemption?
They cannot apply the measure in a way that it would affect a taking. And if they deny, if there's a taking and they still deny that the operator from continuing, that's not allowed under Measure Z.
Where does it say that?
6. So here's 6C. It may grant application that would constitute, may grant an exemption and allow the land use to continue and pass implementing ordinances that make that into effect. Going back to 6B, Measure Z directs the county, instructs it that it cannot apply Measure Z in a way that results in an unconstitutional taking.
So do you agree that if the board found that there was a taking and neither decided to award compensation nor granted an exemption,
Measure Z 6B would not allow that to happen, so the claim for an as-applied takings challenge would be right at that point. But until the county makes that decision, we can't be talking about what hypothetical situation of granting or denying a particular proposal would be. What we're doing is just looking at the face of the text and deciding whether or not, in every single case, you can't avoid a constitution, an unconstitutional taking. I want to go back to the plaintiff's takings claims, which turn largely on these declarations, and we discussed the limited scope of what a facial challenge involves. And for this phase, we didn't do discovery or witnesses or experts because the nature of the legal inquiry doesn't need to go to all that. We just need to look at the text and the relevant statutes and laws to determine if this measure is valid. It's a simple and straightforward test, And the plaintiffs try to unnecessarily complicate it by adding all this evidence in. They use it to their advantage by saying that first, that the submitted declarations have not been challenged. Well, we're not in a discovery phase of trial where we could challenge.
Well, you can challenge by the use of your own evidence, can you not?
Once we start having competing declarations, expert declarations from plaintiffs, expert declarations from interveners, we need a chance to depose them, cross-examine them. We can't take their words at face value. That's the nature of discovery, to test those theories, find out what their assumptions are based on.
Was there anything to prevent you from presenting declarations of your own?
Yes, Your Honor, we're limited in a case talking about the facial validity of Measure Z to the legislative record, the text of Measure Z, and limited information that is the proper subject of judicial notice.
Even when you have not conceded standing?
We are not challenging standing at this point. We think we can.
Yes, but the problem with not challenging it at this point is it ducks the issue, because standing can be raised at any time, right?
Yes.
What is the point of going through all this and then waiting until later on to raise standing? Saying you're not challenging it is not the same as saying you agree that the plaintiffs have standing to raise these challenges.
We can see that at least one of the hundreds of plaintiffs involved in this case have standing to bring a claim, a facial claim against Measure Z.
Which one?
Chevron has standing, let's say.
CRC.
You know, that we don't need to reach those issues in order to address the legal questions before the court today.
Well, if somebody doesn't have standing, how does the court get to those legal issues?
Because of the consolidated nature of this case, the court can issue a ruling on the facial validity of the measure without having to decide whether each individual NARO royalty owner has met its burden of showing standing. And we don't want to get this case bogged down in trying to depose every single plaintiff. I think it's beneficial to all parties in the court to fast forward and try to get to the validity of this measure. So that's the reason for putting aside the standing issue in order to get at facial validity. And so the interveners need an opportunity to depose the declarations of the plaintiffs, need an opportunity to test that veracity of their statements, and need an opportunity to provide counter evidence where we see disagreements. And just looking at the declarations that the plaintiffs had put before this court shows that we can't take those declarations at face value. For example, the declarations that say the oil companies are going to be instantly out of business, those are based on misreadings of Measure Z. And declarations for the purpose of background issues, we don't contest that there may be background issues that are appropriate. For example, the glossary, or what a steam chest is, or what produced water is. But once they get into a legal interpretation of Measure Z, how it impacts their business, the economic impact on their individual operations, that's all, we don't concede any of that. We need to test that and verify that before the court relies on any of that information. That's what the administrative process at the county is set up to do, where all parties can all interested parties can put forward, whether it's their own experts or information that's relevant, and the county will decide then whether a takings has occurred. And it's not until that point that the court has enough information to actually decide on an as-applied takings claim. The plaintiffs, they want to have it both ways. They want to say, we don't have to go through the administrative process and show all these facts and prove our case to the county because we're bringing a facial challenge. And so they get into court, but on a facial challenge, you have to leave all that factual evidence at the door. You have to show that the text of the measure by itself affects unconstitutional takings. What the plaintiffs improperly do is slap that facial challenge label onto all of these declarations and facts and put them before the court, which the cases point out is improper. I again refer you to the NJD Limited versus City of San Dimas case. A facial challenge to the constitutional validity of a statute or ordinance considers the text of the measure itself, not its application to the particular circumstances of an individual. And it's tempting to want to delve into the factual questions that the plaintiffs put forward, how a specific provision will affect a particular operation. Those are very interesting questions, but those will ultimately get resolved at the county. And if there's still disagreement after that, then there's a full factual record for the court to decide whether an as-applied takings has occurred. We're not in that world yet. We're just looking at the facial validity, which is based, as I said, just looking at the text. And the test is very simple. Is it inevitable? Does the mere enactment cause a taking? And is that taking a 100% economic loss? And it's not, it doesn't take very long to read Measure Z. And if on a read-through of that, it's unclear, if there's any doubt that facial takings would occur, I'm sorry, if there's any doubt that in every case an unconstitutional takings would occur, then that fails Lucas, it fails San Mateo, it fails Napa. There's no facial takings there. And just to give a few examples of why we can't take the plaintiff's word for it on those declarations. Again, for Chevron's declarants, they assume that they can't do any steam flooding under Measure Z. And on that basis, they say, we're going to be closing up shop immediately. Well, steam flooding is allowed. The county said steam flooding is allowed. So that assumption just doesn't hold up. The CRC's declarant says our mineral rights are speculative. We don't know what the ultimate value is. We don't know when they're going to drill for that oil. The fact that they haven't done so yet suggests that there's some either physical or economic impairment that has nothing to do with Measure Z. And if they were to drill for that deposit at some point in the future, then they have a process by which to get an exemption through the county. So I heard CRC's attorney say that the takings is instant. That's just not the case. They've shown a mineral lease, but that's only one piece of the puzzle. You have to show what the value is, how much Measure Z is taking away from that value.
He doesn't have to show what the value is to show that there's a taking. It could be worth $1, but if it's taken, that's a taking, right?
The taking has to be 100%.
Yeah, and if it's worth $1 and then 100% of that dollar is
I
taken,
see what
that's
you're
a taking.
I see what you're saying.
He doesn't have to show what the value is, he has to show that it's substantial, that it's taken.
That's 100%. So what happens then when the county views CRC's application and says, we're going to grant you an exemption for these couple parcels? That's not 100% takings. They now have some portion of their value intact, thanks to the carve-outs that Measure Z has on its face. And so just reading the text of Measure Z, we can know that not in every case will there be a taking. And I heard some discussion about whether that interim time between the submission of the application and the county's ultimate determination, whether that by itself would be what's been referred to as a temporary taking. I think there's a little bit of misunderstanding or misapplication of what a temporary taking is, and I want to address that. What a temporary taking is when you have a total and complete taking, and a court has found that that taking has occurred, and instead of compensating for that taking, the agency says, we're just going to rescind this regulation instead of granting compensation. That's what happened in the first Lutheran Church case. And the courts in that instance, in that very limited scope, they said, okay, you rescinded it, sure, but that interim period, there was a permanent taking, and we're going to award compensation for that. I want to contrast that with the Tahoe Sierra case, where the agency took 32 months to decide what to do with this land use application. And the plaintiffs complained, they said, that must be a temporary taking because 32 months is a long time. And the court said, no, that's not how we apply temporary takings. We want to encourage cities and counties to have a reasonable, deliberative decision process and not be rushed into making these decisions. Taking your time is a good thing. And if we said that a temporary takings applied to every single time an agency has to decide something, that would be used as a weapon against agencies, and they couldn't do their job. The Hodel case, cited in our briefs, explicitly encourages counties to use the time it takes to come to a reasonable decision, and a lot of times, because they work with all the interested parties and then arrive at a land use decision, oftentimes you can reach a mutually agreeable decision. And we want to encourage that scenario rather than punish an agency that wants to review all the facts before it makes its decision. So no court prospectively says this process sounds like it's going to take a long time. There must be a temporary takings. That's sort of a misapplication of that principle that I heard repeated earlier today. Turning to Aera, again, their declarations, I don't think we can take at their face value. They say that they can't steam flood after 5 years, so our business is doomed. That doesn't take into account extension for 15 years. That doesn't take into account exemptions that they could get if they just went to the county and asked for them. Until that happens, we don't have a facial takings claim here. This sort of case-by-case analysis that the plaintiffs have presented for you today, Your Honor, this analysis shows just how ill-suited a facial takings test is to consider what should be an as-applied test. And they're playing games with words about what storage is, or what injection is, or what new well is. This is a land use policy in a general plan. As my co-counsel said the other day, it's like a constitution for the county. And that constitution is not going to tell you precisely what happens in every single case. That's up to the agencies, in this case the county, to implement the broad policies to try to adhere to them as best they can given the facts on the ground. So there's nothing unusual about there being some sort of ambiguity in the general plan. If we were to say that any ambiguity made a general plan invalid or unconstitutional, there would be no general plans for any city or county. You can always, especially lawyers, you can always find some sort of ambiguity in the words that are used. The county nor the initiative drafters are required to define every single word with a plain meaning. They're not required to tell you what happens in every single application of the law. That's just beyond the duties of the general plan, any statute, even regulations. Those can be handled by the county. They're more than capable of doing it because they have land use specialists that make these types of decisions every day. So I want to turn quickly to the Lucas test. I think I heard CRC's attorney say that the Lucas holding found that there was a facial takings, and that's incorrect. If you read to the end of the opinion, the Lucas court lays out the test, and you've seen this a couple times now. It denies all economically beneficial or productive use of land. But they remanded the case to see if Lucas, the plaintiff, could meet that test. And one of the things they were looking for in the remand was, did Lucas meet all administrative requirements that are imposed on him? So it's untrue that that was, so even Lucas didn't meet the Lucas test. And despite plaintiff's counsel saying that there were lots of cases that involve the Lucas test, I haven't heard one today that applies the Lucas test and nonetheless finds that there has been a facial takings. So let's apply the Lucas test right now. Let's look at what the measure does on its face. And I want to imagine that we are standing in the San Ardo field the same day that Measure Z goes fully into effect. And remember, the mere enactment has to result in a complete loss of property in each and every case. So let's walk through what happens on day one. What exactly has changed? The wastewater disposal wells that were in operation the day before, those are still in operation, and they won't be affected for the next 5 to 15 years. The existing production wells that were there the day before, those are not affected. Those are exempted from Measure Z's land use restrictions. In addition, operators can re-drill, rework, and sidetrack their wells. Operators, in addition, can still use every method of injection that they were using before for at least 5 years, as I said. They can apply to the county for an exemption from the measure. So looking at that, that's what we have to work with from the text of Measure Z. And it's clear that a review of the text of Measure Z doesn't result in an unavoidable or inevitable or 100% takings. And that's it. That is the end of the court's inquiry for a facial takings challenge under Lucas. We just did it by reading the text of the law and coming to these conclusions about what its effect is, just based on the text. That's why the plaintiffs are so desperate to distract us from what's really at issue here, Measure Z itself. And they load up with factual evidence that is all of their own experts saying what will happen in its application, trying to imply that Measure Z is going to make a certain outcome. They have to do that because when you strip that all away, and all you're left with is the facial takings test, it's clear that there's no facial takings here. I apologize for skipping around.
It's 5 after 3. You've got a while. You are
You have a little bit more. You're
all
right.
right, let's take that. Recess at this time.
Thank you.
Remain seated, come to order. Court is again in session.
Okay, we got the record of Measure Z cases. Mr. President.
Thank you, Your Honor. I only have a few more things to cover. And I'll address a couple of questions that Your Honor had for the county and wrap things up. There was discussion earlier about CRC's claim that the administrative process is somehow deficient because it's not equipped to make decisions under Measure Z. And I want to address that head on. First of all, like I said at the beginning of my presentation, this is the kind of land use decision that county makes with regularity. And the concern that they somehow lose this ability to do so because this decision would imply a takings claim is not a real concern. They have that in the back of their minds every time they deny a permit. Is this going to become a takings? And the courts are comfortable with assigning this role to the agencies. In Williamson Planning Commission versus Hamilton Bank, the U.S. Supreme Court said, until a final administrative decision has been made, one which affords the administrative agency and any reviewing body having similar authority the opportunity to amend the agency decision and or grant a variance. Here's the key part. Whether a taking has occurred through application of a land use regulation the specific property cannot be determined. So the Williamson court says, yes, that agency is going to be making a determination on takings, and that's perfectly all right.
Isn't there generally an exception to the requirement of exhaustion of administrative procedures when it would be futile or inadequate remedy? Isn't that just a basic rule of exhausting administrative measures?
It has to be adequate, Your Honor. You're correct. There's nothing that would suggest that the county's process is inadequate. The Williamson case demonstrates that granting a variance based on whether or not denial would become a takings is perfectly fine and within the agency's authority to do. We also heard from the plaintiffs that the administrative process is duplicative and unnecessary. I think that that's disproven by this flow chart, slide 9 again. It's not that every claim that they bring will automatically wind up in court again. It's only where the county denies, finds a taking in the first instance, denies that claimant from continuing their activity. And if the claimant is unsatisfied with that, they can then come to the court for judicial review.
Well, that's not the only situation which is going to be done in court. I can see about 3 more.
Yes. So that's only one subset of the possible outcomes that would come to court. And the agency is doing what it usually does, is filtering out cases that require the court's involvement, making that first determination. And in a lot of instances, you're not going to have a need for litigation at the end of the process. That's what the Hodel Court, as I mentioned earlier, encourages. Agencies are well equipped to do these sorts of processes. I'll add that the hearing officer that's in charge of the first review of these claims under the county's draft implementation rules will be an administrative law judge hired by the county. So it's not, it's well within their expertise.
Aren't parties guaranteed the constitutional right to a jury trial on the issue of what constitutes just compensation?
They will get that judicial review, Your Honor. That comes after the takings has occurred, and they need to determine what the damages are.
Assuming the board finds a taking, and assuming that it goes ahead and by applying a restriction, I presume you say, tries to modify the application of the ordinance to some extent, determining what is or is not an unconstitutional taking if they pare it down a bit and then the awards just compensation. So the applicant doesn't like it, come back to the court with an amendment on the amount of compensation.
If there is a taking and the compensation isn't just, then that would be an as-applied takings challenge saying that the compensation was not great enough. So that could end up in litigation. But that's not every case. And in a lot of cases, the county could just grant a straight exemption allowing certain activity to continue.
And if somebody else doesn't like the fact that the board granted an exemption, can they file an action for a bit of mandate seeking to have the board put aside the exemption if they grant it?
Well, the agency is always subject to judicial review.
Yes.
That's the nature of administrative law as far as making sensitive.
How do you reconcile this with the Birkenfeld case?
Yes.
You had a process that appears to be far less cumbersome than this one.
The Birkenfeld case that the plaintiffs cite, they note that the agency there was put in an administrative straitjacket. They could not adjudicate on the specific issues in front that were involved in their case. So in Birkenfeld, the agency there was not allowed to consider petitions for rent adjustment. It had no power to consolidate petitions, and the board had no power to delegate the initial factual inquiry to a hearing officer. Those were the defects in Birkenfeld. And let's compare that to Measure Z, where we have an exemption procedure under 6B and 6C. The county has stated that it will allow consolidated petitions if there's nothing to prohibit that. And the implementation draft measures specifically say the hearing officer takes the first crack at the fact gathering and factual inquiry. So none of the things that Birkenfeld court was concerned with apply to this case, and that was distinguished in the Fisher v. City of Berkeley, where they said they laid out all of Birkenfeld's concerns, and they say where we don't have those concerns, we don't have a concern about the process. That's perfectly fine.
Does the Board of Supervisors have the power to adjudicate just compensation under Measure Z?
Yes, they can grant compensation under Measure Z.
Where in Measure Z does it say?
I believe that's...
Given the power to adjudicate what's just compensation.
So I think it's within their power to apply Measure Z in a way that doesn't affect the taking. That says, if you're going to stop a process where there is constitutionally protected right, you've either got to grant an exception or to avoid unconstitutional application of Measure Z, which is required. One way you can avoid that is by granting compensation. And if there are disputes about whether that's just compensation or not, that's a factual inquiry that court or jury is well equipped to rule on.
But it's not compelled by this ordinance to award compensation, is it?
Well, it's compelled by the Just Compensation Clause in the
The
Constitution.
Constitution of the United States requires that, but it doesn't say that the Board of Supervisors has to do it.
It tells the Board of Supervisors that they may not violate the Constitution, and to comply with that requirement, you would have to either grant an exception or award compensation. Briefly on some of the other attacks on the county's process. We heard that Section 6C is void for vagueness or too vague to be constitutional. The vagueness doctrine doesn't really apply to these sorts of instances. All of the cases that CRC's attorney cited are two First Amendment cases, and it is difficult to articulate in set of procedures, what kind of speech is allowed or not allowed, that might prompt a vagueness question. But it's never been applied, or at least the plaintiff's counsel has not put in front of us a case that would suggest that this vagueness doctrine would apply to administrative procedures. And it would be odd to say that it's unconstitutional because we don't know the outcome automatically at the start of every administrative process. That's just agency discretion. If you were to knock it out on due process vagueness grounds, we'd have a problem with a lot of different implementation ordinances where we don't know what the ultimate outcome would be. So I think that's a pretty big stretch to apply the vagueness doctrine outside of the context of First Amendment cases.
Is there any other ordinance you're aware of that allows the administrative agency, which would be on the hook financially if there was a taking, to determine whether or not its actions constitute a taking?
Yes. First of all, the county is never guaranteed to be on the hook financially because they can always grant an exception to Measure Z. That's within the law.
The question is, do you have any, can you just direct us to any other ordinance or provision that allows an administrative agency or a local government agency to decide whether its actions constitute a taking?
I'll point you to the San Mateo case one last time, Your Honor. The provisions of this ordinance shall not be applicable to the extent, but only to the extent, that they would violate the Constitution and the laws of the United States of California. They are determining in San Mateo whether their actions would constitute a violation, essentially a takings, of the United States, under the Constitution of the United States or California.
Pursuant to that language?
Yes.
And
That's,
no other provision? That's the language?
that is the language of Measure A. I'm not sure what the question was. I'm sorry.
Yeah. That's what I'm asking. It was that provision that delegated to the county of San Mateo the authority to determine whether its own actions constitute a taking.
That's correct. And the court looked at that and said that passes muster. Measure Z implements or adopts the very same language.
What is the purpose of the language? Is it Hensley that says that an administrative agency or a government agency is not competent to adjudicate whether its own actions constitute?
That quote is pulled way out of context by the plaintiffs, Your Honor. That was a line referring to the court saying that an agency can't be the final arbiter of a takings claim. And we don't say that the county has the final say. Of course, it's subject to judicial review. And if you read the entirety of Hensler, that becomes apparent. The preceding sentence says, administrative adjudication, if subject to judicial review, does not deny participants their right to judicial determination of their rights. In addition, let me reiterate the Williamson Planning Commission, which said that an agency decision can determine whether a taking has occurred through the application of a land use regulation to a specific property and make that determination. And just one more, Your Honor, the Hodel case, which I've referred to a couple times, they also had an exemption process, which made an exception if the agency needed to, quote, protect valid existing rights. That's 452 U.S. 264, page 294, footnote 36. Valid existing rights is pretty broad, and if the U.S. Supreme Court has no problem with that, if the California courts have no problem with the San Mateo case, if the U.S. Supreme Court has no problem with Williamson planning, then Measure Z is on very, very solid ground. One brief note on amortization. They claim that the amortization provision is also invalid because it doesn't apply to oil companies. We've shown that it applies in a variety of contexts, and we don't need to invent a new legal regime just for one industry here. And further, it fails for the same reason that the takings challenges fail. Measure Z's Section 6A tells you if you have a vested right, you can go to the county and demonstrate that, and the county will respect those vested rights. That's built right into Measure Z. So again, all of this takes us back to what a facial challenge is. And we're just looking at a very narrow scope of review. That is, what does the text of Measure Z say? And, Your Honor, by bifurcating this case and putting those legal issues up front, that made sense because these are discrete legal issues that have very simple and straightforward tests that can be determined just by looking at Measure Z and the case law, and we don't need to consider anything outside of that to reach the determination just on the facial claims here. So it makes sense because we have this straightforward legal test that we can just get out of the way, make a determination on its validity, and then the county can start doing its job of collecting that information, making those factual determinations. Land use decisions don't involve just the oil company's interests. They consider all of their constituents. Just a reminder that Measure Z's purpose was to protect water and air and the health and safety of the county's residents. We've talked a lot about what the potential economic impact might be to the plaintiffs. The economic impact of water contamination or adverse health impacts, those are real concerns to the county too. And the residents depend on the county to protect their interests as well. So when Measure Z was on the ballot,
So regardless of the purpose, if it's a taking, it's a taking. Right?
well, the facial takings under, as applied takings under Penn Central is, the courts have said, no set formula. It's an ad hoc inquiry. And that can involve how the activity will affect the public. The public has an interest in that takings determination, and that can be part of the calculus. Even under Lucas, the court said, you do take a look at what the effect is on public resources, on the environment, on whether the activity is suitable for the locality. So the analysis that the county is going to do is going to consider a lot of stuff. There will come a time when, in some instances, if there's still disagreement at the end of that process, whether a takings has occurred, we'll apply that Penn Central analysis, and the court will determine whether the agency adhered to the law, whether they made an error in the law, or whether they were reasonable in applying that multi-factor test. That's not before the court right now. That's for the county to figure out in the first instance. What we're here for today is to decide the facial validity of Measure Z, and I submit that plaintiffs have failed to demonstrate that there is facial takings because Measure Z is not unavoidably unconstitutional, inevitably constitutional, nor does it affect a 100% taking in every case. Thank you.
Oh, what is your authority for the proposition that be invalid on its face, it must effect a 100% taking in every conceivable application.
That was from the San Mateo case, Your Honor. It has to be on Boyum.
Thank you.
Do you need a page site? I can get that for you.
We'll
Okay.
provide it to the city.
Yes, Your Honor. I will be brief. Let me make a couple of very quick observations. One is that I believe it was the plaintiffs during the initial discussions about the tiering of these cases who asked for discovery. And my memory is that the interveners and the county vehemently objected to that. And the court, I think, said that there wasn't going to be any significant discovery taken. And so I find it difficult today to listen to particularly interveners' counsel complaining about the fact that they wouldn't have afforded the opportunity to take discovery of the witnesses who submitted declarations on behalf of the plaintiffs. The second thing is that I want to just hit this point because I think it is without question this court never told any party that they could not submit declarations or other evidence to support their claims, whether it be with respect to preemption or with respect to a facial take. And the parties are presumed to know the law. These are very fine lawyers who represent the county and the interveners. They know the cases. They've articulated their positions here today very clearly. And they know that the Keystone case was critical of the plaintiff there because no evidence was presented to the court such that a facial takings analysis could be undertaken. And for that reason, and not only that reason, but certainly that was a reason why the court rejected the claim. Now, I want to address one point that Mr. Tanaka made with respect to this temporary take. It's my belief that once there's a take, whether it be temporary or permanent, there's a take. And I don't think that this distinction that Mr. Tanaka is making with respect to whether it's temporary or permanent has any merit. If the court determines that there's been a take, again, whether it's temporary or permanent, then the court should issue an order saying such. And again, there's a process under the Hensler decision whereby the county can then go ahead and make a determination as to whether it wants to disallow the activities notwithstanding the court's determination or pay just compensation. And that could be on a temporary basis or on a permanent basis. So, also, and I think this is an important point. There's been a lot of discussion about that you have to have this 100%, not 95%, but 100%. And actually, I believe it comes out of the Tahoe case, the Ninth Circuit decision, where there's some language to that effect. But that case doesn't say that, and it's interpreting Lucas, it doesn't say that the take has to be instantaneous. I don't think there is a case that says it has to be instantaneous, and I think Lucas, by its own facts, demonstrates that it's not going to have to be instantaneous. But the Lucas take actually doesn't take place when the state of South Carolina issues this prohibition on building the houses. Actually, the take takes place at the time that it would have taken Mr. Lucas to build his houses and either occupy them or sell them or rent them or do something else where he would have had some value. And presumably that would have taken some time.
Yeah, I think the point is whether it's instantaneous or not bears upon whether it's a complete take.
And I don't disagree with you, but you have to look at these things in context. And so, if we have the Aera slide, I really like this slide. I wish I had prepared this slide. This is a great slide. Because what it shows is that in a field that has an estimated life of about 100 years, okay, there's about 100 years worth of oil that we presently know about under this field, it's going to drop off and be zero very quickly. Very quickly. And in my view, when it gets to zero, that means it's done. And frankly, it's done well before that, because no one's going to put any more capital into this operation. The abandonment costs are going to be accelerated, and they're going to be expensive. It's not, you can't just put redwood trees in holes anymore. They don't let you do that. Now you have to fill these oil production wells and injection wells with cement all the way through the bottom, and they even have to cover portions of the formations. It's very technical and very expensive. So, and that's just the well abandonment. You also have all kinds of other materials that have to be removed from the facilities and scrapped. That's a very, very significant expense. And I know that Mr. Kemp testified to it, and there are other witnesses who did as well. I could point to the testimony, but I think you know it in the record, that these abandonment costs will accelerate. And so if you look at that line, it creeps way, way back to maybe 2018, 2019. The effect over a 100-year life is pretty much immediate. And I think you have to look at that in context. I didn't put these slides up before, but I do think it's worth looking at a little bit of the testimony that we have provided, which I think does demonstrate that, in fact, there is a complete take here. Mr. Tubbs' declaration in paragraph 56 says, as currently stated, Measure Z prohibits all injection and impoundment of produced water within 5 years of the effective date of Measure Z. Day-to-day operations in established fields such as San Ardo incur considerable operating expenses and requires the continuous investment of additional capital and resources. These investments are dependent on the assumption that new wells will have an expanded life of 50 to 60 years. No oil company will continue to invest capital and resources into an oil field if all operations I think it needs seats, I think that's a misspelling, within five years. And Chevron is no different. All planned capital expenditures in the field will cease as Measure Z is passed, even assuming that injection and impoundment activities can continue for 15 years. This truncated lifespan of the field is inadequate to justify the level of capital investment necessary to maintain an oil field of this size. Chevron will go somewhere else with its capital and spend that money someplace else where it's sure that it's going to have the full life of the operation. It's not going to spend any more money in San Ardo, nor will Aera. They won't do it. These companies are businesses, and they make business judgments, and they plan ahead. It's not like, they just go willy-nilly and say, oh, let's put a few holes in the ground. Oh, no. They study the site, and they have petroleum engineers, and they have a plan, and it has to be approved. And there's a whole, as you can imagine, a whole process within a company like Chevron or like Aera, or like even some of the smaller operators, to find the best places to put the wells to maximize the value of your production. No one's going to put any time or effort into those types of operations if the field is going to be effectively shut down. And if you look at Mr. Tubbs' declaration at paragraph 60, he says, based solely on the implementation of Measure Z, Chevron will lose substantially all economic value in its property rights within the San Ardo field. Now, I know there was focus on the word substantially, but in this context, and with the other evidence that you've looked at, substantially means all. I mean, you can't say it's going to disappear overnight, because it won't. But in a very short period of time, given the length of time this field would have lived, it will be gone. And Mr. Latham, he also testifies at paragraph 6 of his declaration. Actually, I think it's 22. I'm sorry, it's 22 of Mr. Latham's declaration. He says, the operation of a large-scale steam flooding operation, such as at San Ardo, requires the investment of considerable resources and the payment of substantial operating expenses. Failure to maintain the proper distribution of steam could result in a collapse of the steam chest. Once the steam chest has collapsed, it is unlikely that it will be economic to restore the steam flooding operation, as the steam chest will have to be restored first in areas where nearly all residual hydrocarbons have already been extracted. In other words, you have to start the steam chest over in an area where you've already depleted all the oil. So nobody's going to go back there. And, you know, Mr. Kretzmer put up a slide which had on it, you know, what is it going to look like on day one, and what is it going to look like on day two after Measure Z is in effect. And he says, well, you know, you're going to still be able to sidetrack wells and rework wells. But what was missing from that slide, we're not going to be able to maintain our steam chest. And without our steam chest, that operation is over with. And that starts on day one. Day one. Mary Jane Wilson also testified. In my opinion, based on my experience in the oil industry and my experience in the San Ardo field and other fields in California, the result of implementing Measure Z would be to eliminate oil and gas production in the county of Monterey. I submit to the court that these declarations, which are unrefuted, demonstrate are sufficient evidence for me and others who have pleaded to this court for declaratory relief on a facial case, that we have met our burden. We have met our burden by preponderance of the evidence that this measure will destroy all value in the field, and that there will be no San Ardo within a very short period of time. And that is all I think that is required by the cases. Finally, let me just address a couple of other comments that were made. One, there's so much reliance on this San Mateo case, and the San Mateo case I don't think has any application here whatsoever. First of all, that case did not involve exigent circumstances. Here, as the court has noted it through its colloquy with counsel for the county and interveners, this process is going to take a long time. And what's going to happen during that time? Our assets are going to diminish to nothing. Mr. Kretzmer says that the exemption process, and I'll use his words, were perfectly adequate to address any concerns that we may have, and that we can always bring our claims as applied challenges later on. But I would point out that the exemption procedures are anything but adequate. First of all, you have all of these procedures that you're going to have to go through, and it's going to take forever to get through all of that. They're asking the Board of Supervisors to make exclusive decisions which are exclusively the province of the judiciary. And the notion that the San Mateo case authorized the Coastal Commission to make a determination as to whether or not there's been a takings is belied by the case itself. The case simply says that they can go back and there's a variance procedure there that they can apply themselves to. And if they choose to allow the variance, then I suppose they'll go on their happy way. If they don't, well, then they can go to court. But there was no exigency there. And finally, even if we go through this entire administrative process, as this court has pointed out multiple times, we may not get anything. We may end up with a determination that there was a take, and we don't get compensation regardless. So what is the purpose of going through that process? I submit to the court that not only are the prohibitions in Measure Z facially unconstitutional, but also, of course, the exemption procedure is as well, as Professor Thompson has articulated. Your Honor, unless you have any questions, I am done. Thank you very much.
Your Honor, may I just provide the court with a cite from Lucas that states that 100% taking is required?
I've seen it many times.
Your Honor, Andrew Bassick, on behalf of Aera, Trio, Eagle, the other producers, unless Your Honor has any questions that were raised by the presentations by the interveners, I'll yield to Mr. Thompson to finish this.
Your Honor, I will be very quick. And in fact, it might be better if I simply stay in my seat and so we can proceed to the next issue. But I do want to address just a couple of quick points. Yesterday, we spent a lot of time talking about downhole activities. And this afternoon, at times, I feel like I have fallen down the rabbit hole. And that what is up is down, down is up, and well-known constitutional principles may no longer apply. So I want to just quickly run through a couple of key points. And I want to start out on facial takings claims, so we can put slide 12 from this morning back up onto the screen. Just again to re-emphasize, Lucas itself described itself as a facial takings challenge. You don't have to look at any other case to determine what is a facial takings challenge. Lucas itself, in note 6, noted that the cases repeatedly and unmistakably note that a facial takings challenge is straightforward, where a property owner can show that a regulation denies an owner economically viable use of his land. Second of all, if we could go to the next slide, slide 13, Lucas also again addressed the question of what a property owner needs to show in the case of a facial takings claim. And that is that Lucas, in that particular case, stated Lucas had to show that the Beachfront Management Act denied him economically beneficial use of his land.
Did they send it back down for that determination, or were they talking about evidence that he had already presented?
So what they sent it back down to the South Carolina Supreme Court, Your Honor, was one of Justice Scalia's points in a footnote, was the question of whether or not, as a matter of background principles of law, Mr. Lucas was permitted to develop his property. Because one of the arguments was, well, it would have been a nuisance to develop his property, and therefore he never even had a right to develop the property to begin with. And so one of the things that Justice Scalia said is, we're not going to determine South Carolina common law. We're going to send it back to the South Carolina Supreme Court to determine whether or not, in fact, before the legislature passed the act that was at challenge, whether or not Mr. Lucas would have been able to build 2 houses on his properties. Just because I cannot resist, we went back to the South Carolina Supreme Court. South Carolina Supreme Court said, wouldn't have been a nuisance problem. In fact, as you saw in that picture earlier, there were houses built up and down the beach. Therefore, it was held to be a taking of Mr. Lucas's property. The state then paid Mr. Lucas compensation and turned around and sold the 2 lots to somebody to build houses on, so that they could recoup the investment that they had made. So one of the things that we were told by counsel for interveners, not once, not twice, not 3 times, but I think 4 times, is that if we simply look at the NJD Limited versus San Dimas case, which is at 110 Calat 4th, page 1428, you can see that citation at the very top of the page. We'll see that, in fact, under a facial takings claim, you aren't permitted to produce any evidence. So we pulled up the language from NJD Limited, which starts out on page 1448 to 1449, saying we're not holding that no evidence may be received in a facial regulatory takings case. And in fact, I can't even imagine how you would make out a facial takings case if you couldn't put in evidence that, number 1, you had property, and number 2, you couldn't use that property. It would make it not simply difficult, it would make it impossible. And then the court goes on to say, for example, in Lucas, the plaintiff had a duty to demonstrate his parcel was subject to South Carolina's Beachfront Management Act. Certainly a party has a right to present relevant evidence, but the amount and type of admissible evidence depends on the type of takings challenge, be it categorical or regulatory, facial or as applied. And what CRC has tried to do in this case is to take exactly what the Lucas Court looked at and to provide Your Honor with what we think is a reasonable amount of evidence on each of those various points, and hopefully we didn't provide too much because we realize that Your Honor wanted to keep the amount of evidence in this stage of the case to the minimum amount necessary to demonstrate our claims. And although again, I think this is fairly clear at this particular point, in the pretrial order that you signed on June 26, 2017, after we had had lengthy discussions in the pretrial conference about what type of evidence would be permitted, and after counsel for the various parties discussed this, Your Honor, and this is on page 4 of your order, again, of June 26, 2017. On page 4, this is paragraph 13B. Your order says, the court appreciates that some factual showing must be made by plaintiffs even on a facial challenge to the constitutionality of the ordinance in light of, and then you cite to the Keystone bituminous case. And then you go on to say, such factual showing will be allowed at trial to the extent factual disputes are not resolved by stipulation. We actually did try to get stipulations to our evidence, but we're not able to get stipulations. That's why we put everything in by declaration. As you pointed out, both the county and interveners had an opportunity to put in their own evidence if they thought that in fact we didn't own the property that we said we did, or somehow, I'm not quite sure what one would do with a mineral interest that you're not permitted to drill on. It's hard to put a trail inside a big mineral interest, but to the degree that the county and interveners thought we could, they could have presented an expert witness or a declarant saying that. And my guess is, Your Honor, but I will admit to being speculative at this point, is one of the reasons we don't see that evidence is that it would have been hard to find any such evidence in this particular case. You own the property, you have to drill in order to produce oil. The property is now fabulous for CRC. So I want to turn from Lucas, and this will be very short. If we could put slide 35 up on the screen from this morning. Actually, I thought it was 35, but it's the picture of the typical land use permit process and Measure Z Section 6 process. And I'm sorry, Your Honor, that's not perfect. This is the slide. And we could just have all of the animation run down so that it's all on the screen together. I think in talking about the Section 6 process, that this slide is critically important because it shows the difference again between your very typical land use permit process, the one that property owners normally need to exhaust before they get down to the bottom and file a takings claim, because until it's exhausted, you don't know how a permitting process with lots of individual parts are going to be applied to a particular piece of property. And the Section 6 setting, which again is, as far as we can tell, unprecedented. We have looked for cases, and I can assure Your Honor, we have not found anything like Section 6. And the reason is, and we've emphasized this, Your Honor, already, is that Section 6 applies where there is already a taking, and where the question is, has there been a unconstitutional taking? And in fact, if you look at interveners' slide where they try to show the process, they also note that the question the Board of Supervisors asks in these questions is the legal question of whether or not a taking has already occurred. And so you've basically taken the judicial process and assigned it over to a political body. Now, counsel for the county, and I'm not quite sure I understood his argument, and therefore could be misrepresenting him, and I'm sorry if I am, but seem to think that because of the fact that if the county went through the Section 6 process and went all the way down and granted us an exemption, and assume the exemption itself is constitutional, that the county would still be liable for a temporary taking. Council suggested that that meant that there couldn't have been a facial taking to begin with. But the truth of the matter is that whenever there's a facial taking, if the government decides after a trial, like a trial here, that it's not going to enforce the ordinance, there can still be a temporary taking with a loss in the value during that period of time. And the reason we suggested there was a temporary taking here is that effectively what Measure Z tries to do in these cases is to, again, take the judicial process and move it over and say, okay, decide whether or not there's a taking. And if so, maybe we will grant an exemption. Well, there would still be a temporary taking. And in fact, French English, this is at 482 U.S. at 321. So again, First English, 482 U.S. at 321, says that where the government's activities have already worked a taking of all use of the property, right? That's basically what the board would need to decide in this particular case. No subsequent action by the government can relieve it of the duty to provide compensation for that temporary taking. A third point that's worth just emphasizing here is that, as I understood, the county's council also suggested that there's no problem with Section 6 because at the end of the day, this will all come back to you and you can address it at that point. So there's no problem putting us through this particular administrative process. And as we discussed earlier, no matter what the county were to rule, if Section 6 was valid, it's almost inevitable that it's going to come back to the court. Several things to emphasize. We're right now before the court. The takings issue is clear. It is right. We should not be forced into a Section 6 process, particularly because, as we've shown earlier, the Section 6 process is invalid. So even if it comes back to you at some point, you can rectify everything, and Section 6 is invalid. That's the end of the question. Furthermore, simply sending the mineral rights holders through this lengthy process to come all the way back to you, as you pointed out already, raises Birkenfeld invalidity. And Mr. Renwick earlier noted that he has a lot of small clients out there. And so one of the concerns that I think the court needs to consider is also the problems of sending a lot of small mineral rights holders through a very lengthy process only to come back in. But again, the bottom line is that Section 6 is invalid. That's the issue. The other thing that I understood counsel for the county to say is these things take time. Taking cases take a long time. But Lucas cases don't. The evidence is pretty straightforward on a Lucas case. You have the evidence in front of you now in order to rule on. Final thing I just want to emphasize is, again, the difference between the typical land use permitting process on the one hand and the Section 6 process on the other. In the typical land use permitting process, generally property owners need to exhaust that administrative remedies in order to determine exactly how the regulations apply to the particular property. That's why you have a lot of cases out there saying, we want the property owner to exhaust administrative remedies. Again, that's very different from a situation where the taking has already occurred. And the question is that to be resolved by a court or by the board? And if we could go to, we call slide 5. I just put together some of the cases, and this will be obviously available to your honor, so you do not need to write all of these down right now. But these are some of the major cases that the interveners and the county cited. And you'll see that none of them bear any resemblance to Section C. All of them are traditional zoning cases where there was a traditional permitting process that the property owner could go through, and it could be determined whether or not, in fact, there was any type of a constitutional issue to begin with. And this is, I think, cleanly laid out. I won't go through it, except SMCRA is the surface management, and I don't even know what SMCRA stands for, but it's fun to say, SMCRA. Your Honor, I think one of the clearest cases on this point is the Hensler case, which has been cited to you several times. Clear in terms of the difference between your traditional permitting process and what Section 6 says. Because as both counsel for interveners and counsel for the county noted, in the decision it says at one point, administrative adjudication in the course of exercising an administrative agency's regulatory power, right, that's your traditional process, does not deny participants their right to judicial determination of their rights. So the court is basically saying, nothing wrong with that. But then the court went on, the very next sentence, we agree with the healing court, however, that an administrative agency is not competent to decide whether its own action constitutes a taking. And so the court here made that distinction, and this is 8 Cal 4th at page 15 to 16. So again, they said, hey, nothing wrong with the traditional administrative process, but an administrative agency is not competent to decide whether or not its own actions constitute a taking. So finally, Your Honor, we think that on behalf of CRC, we have demonstrated a facial taking. We've shown that we own mineral rights. Measure Z says no new wells, and without new wells, we can't use mineral rights. We had a fairly easy case, we think, of proof to put on, and we set it in front of you. We also believe that measure Section 6C is invalid for 3 independent reasons. The first that we discussed at length is that the Board of Supervisors is not competent to decide whether or not it itself has taken property. That is the judge's province. Second of all, that the standards are vague. And third, that the process set out here violates the Birkenfeld standards. And we think the Birkenfeld case is quite clear. So just going then to rebuttal 6. You asked earlier about what relief we thought was appropriate, and looking at the cases. This is a modified version of that slide earlier. We think that the appropriate relief here is, first of all, to declare that Measure Z effects a facial taking of CRC's property. We believe it is then within the court's authority to stay that for a reasonable period of time, and that then gives the county the opportunity to determine whether or not it wants to actually apply Measure Z against CRC and pay compensation, or not to apply Measure Z against CRC. If the county decides to enforce it, then we would return here to the court to determine compensation. If the county decided not to enforce it, then that would be the end of the matter, unless we decided that we wanted to request damages for a temporary taking. In our original complaint, we did have an action for inverse condemnation, so we think we would not need to apply anything new at that point to request compensation. And as we mentioned earlier, we also request a declaration that Section 6C is invalid. So with that, Your Honor, we've been discussing this issue for a long time. Thank you very much for your attention.
Thank you, Mr. Thompson. Mr. Plum?
Thank you, Your Honor. We're going to turn now to the single subject matter rule, and I think I can make some pretty good progress if we could perhaps go to maybe 440 today. I don't think I'll finish, but I think I could get deep up enough into it that we could make some progress.
Your Honor, to just preserve our objections, that the slideshow you're going to see will include information and evidence that we think is inappropriate, try to strong argue on behalf of the county. And we are not going to object to written presentation, but we will address it during our.
Thank you for pointing that out. That's, I'm going to see what campaign materials and.
Yeah, and I'm going to try to, as I go, flag those issues for Your Honor if there's no mistake about whether
Simply, so we also.
Thank you, Your Honor. Maureen, could you pull up the second slide? Your Honor, we're here to talk about Article 2, Section 8D of the California Constitution, known as the Single Subject Matter Rule, enacted in 1948, ironically by voter referendum itself, which says an initiative measure embracing more than one subject may not be submitted to the electors or have any effect. And if we go to Senate v. Jones, Your Honor, this may be the most important slide in my entire presentation. Senate v. Jones is a key case that came out in 1999 in the California Supreme Court. And despite a lot of the representations by the opposing parties' briefs, the California Supreme Court has counseled courts that the single subject rule is neither devoid of content nor toothless, as some suggest. And to be fair, Your Honor, there have been many cases challenging initiatives on this ground, and the large majority of them have rejected such challenges. But I'm going to try to make the presentation here today, Your Honor, that we fall within the Jones line of cases concerning misleading voters. And just to refresh Your Honor's recollection, Jones in 1999 affirmed two recent Court of Appeals decisions, the CTLA decision and another decision striking down initiatives on single subject matter grounds. And in that instance, it struck down the Let the Voters Decide Act of 2000. And if you go to the next slide, here are the key holdings of Jones, and then I'm going to harken back to Antelope Valley. First key holding is that the single subject rule safeguards the people's precious right of initiative from the very risks of confusion and manipulation that the rule is intended to eliminate. And so my burden here today, Your Honor, is to show that sort of Jones confusion or manipulation, and that's what I'm going to endeavor to do. Secondly, we've heard a lot about the precious right of the democratic process of initiative. But what Jones tells us and counsels is that the single subject rule itself was enacted to protect the integrity of this right. And so they're on equal constitutional footing. The right to enact initiatives and the court's duty to act as a check and balance as part of the separation of powers in California jurisprudence to make sure that these initiatives are appropriate. And that minimize the risk of voter confusion and deception rule goes back to the Prop 13 case of Antelope Valley. For the next slide. And so have the courts tell us, or tell the courts, to take a look at these initiatives. Number one, Jones tells us, look at the initiative from a realistic and common sense perspective. Number two, focus on whether the average voter would have been misled. And number three, consider the risk of voter confusion. We don't need to prove actual confusion, we need to prove the risk of voter confusion. So what was the single subject matter violation in Jones? In Jones, the problem was voter manipulation. And as you'll hear today about Measure Z, or actually tomorrow from my esteemed colleagues, all of the provisions in Jones were set forth in the initiative text. That initiative had a lot to do with the way legislatures receive their salaries, and also had to do with the way legislative districts are shaped. And they all fell in the umbrella of letting the voters decide these issues rather than legislatures themselves. But what the proponents did in Jones is they used a hot button issue, capping legislature salaries, to sell more obscure ones having to do with redistricting. And what the Supreme Court said in that case was, by using this hot button issue of capping legislature salaries, that in fact in the initiative wasn't really happening, and that the way the initiative proponents were articulating it, they kind of set up this bogeyman, for lack of a better word, Your Honor. By using that bogeyman to sell these other initiatives that they really cared about, the Supreme Court of Jones in 1999 says, you violated the single subject matter rule. And so this is a key part of Jones's analysis, Your Honor. And again, like all the other slides that both sides are presenting, we'll make sure that they're all on the record for Your Honor. What Jones says on page 1163 is, even if we were to assume that the theme or objective of remedying legislative self-interest, this was the raising salaries point, is not exclusively broad and would permit the combination of such otherwise unrelated proposals, like the legislative district rules. The initiative before us cannot properly be defended on this basis. And so what they're saying in that first sentence, Your Honor, is even if you meet the germaneness test, even if you meet the reasonably related test, even if all these things fall under the articulated purpose test, here's what the next sentence says. Although the text of proposition obscures this point, in reality, under existing laws, members of the legislature do not control their own salaries and thus cannot raise their own pay, as the initiative implies. Go to the next slide. The essence of Jones is that joining together multiple provisions in an initiative for improper tactical purposes strikes at the heart of the single subject rule's purpose of minimizing voter confusion and deception. And I showed you this slide the other day. What is one of the key pieces of evidence that Jones relies on? It relies on this San Francisco Chronicle newspaper article that the Supreme Court cited itself, determining the relevance issue for itself. And what you have is an admission from the proponent of the initiative, Mr. Costa, saying, yeah, I was able to get votes by getting people in shopping malls excited about this legislative pay thing because they're not really interested in issues like reapportionment. And the case law is clear, Your Honor. Myopia is not required. You can look at these materials, and the Brosnahan case says, the Brosnahan case had to do with very comprehensive criminal justice reform that was enacted by initiative kind of in a response to the Roseburg Court. And one of the things that the Supreme Court said made it feel comfortable to uphold that legislation is that there had been a lot of debate about this. There have been newspaper stories, radio stories, television editorials, public debate involving candidates, etc. And Chief Justice Byrd herself cited this political emergency. Other cases have mentioned looking at the history of a measure, chemical specialties, which struck down an initiative, talked about that. And what I find most interesting every time the interveners object to our evidence is they cited a lot of extra Measure Z record evidence in their own submissions. If you look at RGN A, B, E, and F, they asked you to look at this extra record evidence in their brief.
The Brosnahan case actually involved a discussion of the admissibility of that kind of...
The Supreme Court decision itself did not grapple with that admissibility issue, but it did advert to the fact of the existence of these editorials and the like to say we, the court, from this common sense perspective, thinking about the average voter, feel confident that they understood what they were enacting. That we feel confident that they knew that they were enacting comprehensive criminal reform. So it's a key part of their ruling. And I'll let Your Honor know, other areas of the law, particularly in the equal protection context, where intent, voter volition is at issue, or the legislator's volition is at issue, you can look beyond the text of the statute to determine why something was enacted. So take, for an example, a law that discriminated against one group of people in a particularly harsh way. Equal protection cases say that you can look beyond the text of the statute itself to see if there was a malintent to discriminate against those individuals. And I promised Your Honor a very short 5-page brief on the evidentiary issue, and we'll cite those cases for Your Honor when we do so. So now it becomes my burden, Your Honor, under the Jones case, to show Jones-like deception and manipulation and confusion here. And so I want to start out with this basic predicate fact. what the county has told us again and again and again is that there's no fracking in Monterey County and that it's not likely to occur here. We have Supervisor Salinas saying that. We have county staff saying that. We have Supervisor Potter saying that. We have Supervisor Phillips saying that. And I note for your honor that all of these come from the administrative record that the county prepared in connection with the litigation in this case. In our submission, Your Honor, we too confirmed that fracking is not a real issue in Monterey County. Mr. Boyum, the former head of DOGGR, took Measure Z finding 3 head on. And that finding was that, fracking could become widespread in Monterey County. He said, no, that's not supported by the geologic data. Mr. Gore said hydraulic fracking is not required for economic production in Monterey County. And Mr. Miller actually explained that hydraulic fracking would in fact be detrimental to efficient exploration of the San Ardo and other fields. Again, no contrary evidence has been submitted. Next slide, please. And Your Honor, the county said the other day here, Mr. Tanaka, and let's also be clear, as Your Honor pointed out, that there is no fracking going on here. So, against that backdrop, Measure Z was sold as an urgently needed fracking ban, much like the much needed cap on legislative salaries of Jones. It's titled at that, its stated purpose did that, its asserted findings did that. In public statements, and Your Honor, I'm not focused on public statements that some random person made. I'm focused on public statements that authorized representatives made of PMC and that PMC made itself on its website. We're looking at campaign ads and signs that they created, and on lobbying communications that are, again, not by some random person. I'm talking about the plaintiff in this case, Dr. Solorio, and other key people at PMC. So you start with the title, Protect Our Water, Ban Fracking, and Limit Risky Oil Operations Initiative. You look at finding 3 that we heard a lot about in the last couple days, and it says fracking could become widespread in Monterey County. That's an utter falsehood, Your Honor. There's utterly no evidence that that is ever a threat or risk here.
Doesn't focusing on the deception really take us away from the primary analysis of the single subject, whether they're reasonably germane on the purpose. In any political campaign, isn't it almost expected that there's a certain amount of duplicity and spam and shorthand buzzwords employed in trying to sell some idea of a person?
It's a good question, Your Honor, and I would submit that there's really 2 lines of cases under the single subject matter rule. There's the case where you have all these crazy different subjects that are kind of put together. This was the truth in advertising case that we talked about, where they said you had to, make certain disclosures in all these different industries. And the court, I believe it's in, not in CCLA, but I don't know which case is that. In chemical specialties, the court says, look, this is just a hodgepodge, and these are all these different subjects that you tried to get enacted before the legislature. You couldn't get it done. You've jammed them all together, and that is inappropriate. So chemical specialty strikes it down in that grade. If you read Jones carefully, Your Honor, what they're focused on there, and that's why I pulled up slide number 8. What they say there is, look, even if you can meet that reasonably germane test, if you're using this kind of a blatant falsehood to get this thing enacted, no, you violate the rule. But there's even a footnote in Jones, Your Honor, and I'll ask Ms. Wells to grab it for me, that says, we're going to strike this down in single subject matter rule grounds, but we can even hypothesize a further claim that there would be instances where we might just strike the statute down just on the fact that it was brought in such a misleading and deceptive way. And that's footnote 12, where they talk about the misleading nature of a position. So Your Honor's question is an excellent one, and I think most of the counties and interveners' arguments, Your Honor, are directed to a chemical specialties type argument, which would be us saying, hey, this is just a hodgepodge of different topics. And what we're really asserting primarily is a Jones claim. I'll get to the reasonably germane type claim, the chemical specialties claim. depending on my timing, maybe tomorrow. But right now, I'm really pressing the Jones claim. So if you go to the next slide, Your Honor, and again, I don't want to cut anybody off and making objections, and they can talk about this a lot. But Your Honor, I'm focusing here on, I believe she's a doctor, Dr. Laura Solorio. She's a plaintiff. She's the named intervener in this case. These are whose statements we're relying on. We're relying on official emails that PMC sent out lobbying. We're relying on their flyers, their campaign flyers, and all those documents, Your Honor, some of which are in the administrative record, some of which we got to take judicial notice of. Again and again and again, the subject matter of those emails is the anti-fracking initiative. That's how this thing was talked about. That's how this thing was sold. And, Your Honor, I would argue that these communications are probative of the types of communications that were used throughout the campaign. Every time that they were communicating with the most important individuals on the receiving end, i.e. the county, i.e. at these big board meetings, they always referred to this initiative as the anti-fracking initiative. And the reason they did that is because it's a hot button issue. And I promise you, Your Honor, I will not play the Governor Jerry Brown interview where he talks about what a hot button issue is, but I don't think it's beyond the pale to argue here that obviously anti-fracking sentiment and the like is a very hot button issue in California. And so that's why you see these signs, Your Honor, that we're so focused on fracking. And we'll go through these pretty quickly, Your Honor, but this was the official message, if you look up on the screen, that was repeated again and again and again in numerous places in Spanish. And Your Honor, the sources that we're looking at come from PMC's Facebook page and their website. These aren't random people we pulled out and cherry-picked. Go to the next slide. These are the things that appeared on their Facebook page and on their YouTube channels to sell the initiative. And with your indulgence, I'll just play a couple of very short videos that show the sort of message that they were trying to create about it.
Everybody, Mark Ruffalo here, standing outside a climate rally in Los Angeles saying to vote yes on Proposition Z. Vote yes on Proposition Z. Take control of your own destiny, stop fracking in your community, and send a message to the rest of the United States that we will no longer allow these major corporations to pollute our water and our air and our families and our beautiful children that we love so much.
Why don't we stop that right there? We'll go to the next one. No, please just go to the next slide. That's pretty loud.
Fracking contaminates the water we drink, the air we breathe, and they make...
Thank you. I apologize that it was so loud, Your Honor. We didn't get a chance to test it before we played it. So if we could go back one, please. So again, what's the test? The test is focusing on minimizing the risk of voter confusion and deception. And these are the words, cases like Jones, and cases like CTLA. CTLA was a case where buried in a big insurance initiative was this special exemption to engage in lobbying and wouldn't create conflicts of interest for those who lobbied in that industry. What does the courts focus on? Amador says minimize risk of voter confusion. Jones says likely misled, potentially confusing or misleading nature, risks of confusion and manipulation. CTLA, risks of confusion, potentially deceptive, significant threat that voters are misled. And I submit to Your Honor that all that's met here. And to me, again, this isn't like a binding, the proof that I'm putting up now, which comes from the Monterey Herald, it's not binding on you. It's not some admission from PMC, but I do think it is persuasive, relevant evidence as you make that common sense review. Monterey's not a huge county. Not a lot of people voted for this, but this is the paper of record, and this is its editorial board. And it asked, so why are the SMZ campaign materials featuring in large bold type ban fracking? Is it perhaps because in the national stage, fracking is a red flag word these days? And the conclusion was Measure Z is an obvious attempt to mislead the public. And I get it why the interveners in the county want you to close your eyes and ignore all this evidence, because it's terrible for them. It's devastating. The paper of record is saying this is an obvious attempt to mislead the public. And under the Jones line of cases, what the court instructs Your Honor to do is to make sure that there's not a risk of such confusion. and yet it was present and abundant here. There was a second means of confusion used by the proponents to get Measure Z passed. They got into the ballot statement a representation that Measure Z preserves current oil jobs and county tax revenue. Go to the next slide. And I'm not going to play this video, Your Honor, but this is a gentleman who is the member of the legal committee for PMC, and I'll represent to you that in a televised public debate, he said there will be zero loss of taxes if Measure Z was enacted. Of course, as you discussed with Mr. Tanaka earlier this morning, the county supervising assessor had concluded that Measure Z would shut down oil production. And I don't pretend to know the inner workings of the county, but my understanding is his supervisor may have edited that document later, Your Honor, but I think the reason he edited that document later is because there was deep concern that his conclusions could be used in a case like this against the county. And what happened? The interveners, PMC, successfully lobbied to shut down that conclusion from being put in any of the ballot materials. And the PMC also successfully quashed impact reports, claiming any analysis would be doing the impact of the oil industry. One of the county supervisors wanted to get that impact analysis done, but they successfully objected to that, citing the threat of lawsuits. But what do we know? What's the reality? They've promised zero loss of jobs, zero loss of taxes, and I'm going to start at the last bullet here. I think Mr. Thompson, my colleague, pretty persuasively showed that CRC is no longer going to owe the $1.5 million in taxes if Measure Z is enforced in effect. And the undisputed evidence up and down is that oil and gas production is going to be shut down if Measure Z is upheld and enforced. Perhaps some of the worst evidence of this, Your Honor, after telling voters there'd be zero loss of jobs, zero loss of taxes, is that in one of the first filings interveners made in this case, they argued very vociferously to you that allowing the operations to continue as they've been going presently would effectively nullify the protections of Measure Z. So they were asking for the shutdown that they said wasn't going to happen. Again, what did PMC say, PMC and its lawyers groups say after the election? Well, one organizer told the Salinas Californian, we're ready to transition to renewable energy now. Measure Z was a huge win because it was going to shut down the oil industry in San Ardo. And the Center for Biological Diversity, who's here as counsel for the interveners in this case, says we have a plan to phase out the existing enormous production here. And then yesterday, when my colleague, who's going to speak on behalf of the interveners in response to my arguments, stood up, he told me the voters have spoken and they've said they don't want new holes in the ground. So they can drill, and you asked, so can they drill new holes in the ground? And he said, no, Your Honor. And without an ability to drill holes in the ground, CRC's rights are valueless, and the $1.5 million that is paying in taxes to the county, we're going to pay those taxes anymore. And whatever one thinks about the debates of, the immediacy of Chevron and Aera's production, whether it's, immediate or very close to immediate, obviously their production is going to diminish as well, and there's going to be lost jobs, there's going to be lost taxes. And it was the design of the architects of Measure Z, the very design of the architects of Measure Z to shut down production. Your Honor, that's the basic end of my Jones argument and submission, and I can pick up quickly and go through the second half of my submission in the morning. I think that'll take maybe 15, 20 minutes.
Yeah, we'll recess until tomorrow morning. We will resume at 8:30.
Thank you, Your Honor.